romance novel.
Never?
And she said, just trust me, read it. So I read it, and by the end of the book, I couldn't even read the text on the page because I was crying so much. My wife was in bed next to me, and
We're so proud to officially welcome you to the Blake Brown TYB community. Community means everything to us at Blake Brown. We believe in respect, collaboration, and working hard to create products that truly matter, products that work for us. But more importantly, products we want you to love. From scents and packaging to clean formulas that make you feel good using them, every detail is intentional. Sometimes things don't go exactly as planned, and you just have to improvise, like turning a lemon upside down because it won't fit the right way. Moments like that remind us to stay real, stay human, and keep things fun. I also can't help but say how much I love the way my husband dresses, and I'm equally inspired by Gigi Hadid's style. Meanwhile, Blake Lively found herself called out in court filings on Friday, and the situation was striking to watch unfold. There are two legal paths the judge could take to dismiss her lawsuits, and both have clearly unsettled her supporters. Her fans have been working overtime to defend what many see as defective pleadings and a deeply flawed lawsuit against Justin Baldoni and Wayfarer. At the same time, Wayfarer's attorneys have continued to press forward, showing sharp legal skill, effective argumentation, and even a touch of sarcasm, all while grounding their case firmly in law and fact. Despite nearly a year of noise and controversy, the reality remains that Blake Lively's case is fundamentally flawed and may never reach trial. The uncertainty now lies in how the judge will respond, as either route to dismissal places Blake in a difficult position. In her response to the motion for judgment on the pleadings, she abandoned several arguments and suggested the court simply convert the matter into a summary judgment. However, the judge had already made it clear in a prior order that the motion for judgment on the pleadings was timely and would be considered alongside the summary judgment, not merged into it. He stated he would review both simultaneously, not reshape one into the other. Notably, the Wayfarer parties did not rely on any extrinsic discovery evidence in their motion. Instead, they confined their arguments strictly to the pleadings and the documents already filed in the case. Blake Lively made several serious mistakes that may ultimately prove fatal to her case. First, when she filed the lawsuit, she failed to submit the CRD complaint in the name of It Ends With Us Movie, LLC. She later admitted that she amended the complaint after receiving a right to sue notice, but no new right to sue was issued because the matter had already been closed. In practical terms, that means she never actually obtained a valid right to sue notice on behalf of It Ends With Us Movie, LLC at all. However, the more significant problem for Blake in the motion for judgment on the pleadings lies in the extraterritorial application of her phir claims. California law is quite clear that phir does not apply to conduct occurring outside the state, to non-California residents, or to situations lacking a clear connection to California. There must be an established nexus between the alleged conduct and the state. And Wayfarer argues that Blake has utterly failed to demonstrate such a connection. According to them, that failure alone is sufficient grounds for the judge to dismiss the case outright. The judge could also consider the EEOC dismissal that Blake filed in this matter. Notably, Blake revealed for the first time that she received an EEOC dismissal around January 21, 2025. That timeline is unusual, as the EEOC typically does not dismiss cases within a matter of weeks unless there is a procedural defect, lack of standing, jurisdictional issues, or non-compete. A dismissal is verified confirmation that the EEOC chose not to move forward with the case. Unlike California's phir process, an EEOC investigation cannot simply be waived, as the agency has a right to conduct due diligence and employers have a right to respond. In this instance, the unusually fast dismissal strongly suggests procedural issues rather than a substantive review. The likely explanation is timeliness. The alleged incidents occurred in May 2023, yet Blake did not file her EEOC charge until December 2024. Well beyond the 300-day statutory deadline. Under those circumstances, the EEOC can automatically dismiss sexual harassment claims as time-barred when the dismissal documentation is eventually made public. It would not be surprising if it explicitly states that the EEOC lacked jurisdiction due to Finally, in Wayfarer's motion for judgment on the pleadings, they argue that Blake effectively abandoned her allegations regarding an adverse employment action. They point out that she failed to identify or justify what the adverse action actually was, and because she did not address it in her response, Wayfarer contends that the argument has been waived entirely and must therefore be dismissed at this point. It's unclear whether the judge will dismiss the case, largely because Blake's response focused almost entirely on asking the court to convert the motion into a summary judgment. Her legal team made an extremely rare and arguably risky strategic choice by largely ignoring the arguments raised in the motion for judgment on the pleadings and instead urging the judge to treat the matter as a summary judgment. In my view, that decision likely stems from their inability to meaningfully address some of the issues raised. So rather than responding, they effectively asked the court to disregard them. The danger in that approach is that failing to respond can cause the court to treat those arguments as unopposed, and unopposed motions are often viewed favorably for the party bringing them. That risk is especially clear when it comes to the adverse employment action issue. Wayfarer told the court that Blake didn't even attempt to argue that she suffered an adverse employment action and has effectively abandoned the claim altogether. As a result, they argue that her retaliation claims must be dismissed. In their filing, they state that because the plaintiff concedes she failed to plead an adverse employment action, her retaliation claims under FEHA and Title VII should be dismissed outright. Wayfarer also challenges Blake's arguments on choice of law, pointing out that contractual choice of law provisions cannot override the statutory limits of California law. Blake's position appears to be that phir can apply extraterritorially because a choice of law clause says so, but California law is quite clear that phir does not apply outside the state, and a contract cannot bypass those statutory restrictions. On the pleadings alone, Wayfarer presents some very strong arguments. At the same time, the summary judgment briefing provides the judge with another potential off-ramp to dispose of certain claims. That may explain why Blake's team is pushing so hard in that direction. Frankly, I don't think they believe they can win on the pleadings, and I suspect they know it. Instead, they appear to be pursuing what they see as their best remaining option, which is summary judgment. But that strategy comes with serious risks. By ignoring the motion for judgment on the pleadings, they invite the judge to agree with Wayfarer and dismiss the retaliation and phir claims outright on that basis alone. Even if the court reaches the summary judgment stage, Blake faces an even steeper challenge. At that point, she must establish that she was actually an employee, not just alleged. Wayfarer directly disputes that she was an employee at all, and proving otherwise will be essential for her claims to survive. She was an independent contractor. I actually raised this issue a long time ago and received a lot of pushback from some attorneys on this platform who claimed I didn't understand the law. But based on how Wayfarer is now arguing the issue, this appears to be exactly how the law operates, just as I originally understood it. It's also worth highlighting several points raised by Alexandra Shapiro in response to Blake's summary judgment's opposition. Her opening line is particularly striking. She writes that Lively spends pages attempting to manufacture factual disputes, but the material facts are undisputed. According to Shapiro, Blake's own opposition confirms that she launched an aggressive legal campaign over minor grievances, all of which were addressed and resolved during the film's production without any need for litigation. Shapiro explains that Blake recites a list of alleged harassment claims, ranging from raised voices and defensiveness to a conversation that Blake herself initiated. That conversation, almost certainly about circumcision, was one Blake later described at the time as a She also fails to allege that any conduct continued after she asked for it to stop. In fact, once concerns were raised, the conduct stopped, and the parties went on to collaborate successfully, producing a film that brought Blake not only significant financial gain but also substantial professional accomplishments. She herself praised the Producers Guild of America as rare for a woman in the industry. Despite this, she now claims discrimination, arguing that her heavily negotiated, bespoke contract was violated even though she never signed it, and that despite exercising near total control over the production, she was merely an employee. She also alleges that the defendants unfairly relied on professional PR firms while ignoring the fact that she and her husband openly criticized Baldoni and helped generate negative press against him. While she alleges a massive smear campaign, she fails to identify a single false statement made by any defendant about her. Shapiro concludes that Lively's claims simply do not meet the required legal standard. When you step back and look at the issue as a whole, much of what Blake points to in her summary judgment response reflects the realities of filmmaking. People say things they don't mean, tempers flare, directors and actors argue, disagreements arise, and misunderstandings happen. In Blake's case, however, she appears to have taken every one of those ordinary workplace conflicts and reframed them as evidence of harassment. This section effectively sets the stage, signaling to the judge not to be misled by Blake's claims of a hostile work environment, claims that don't actually hold up, because the alleged conduct wasn't hostile. One of the sharpest observations Wayfarer made in response is that Blake essentially conceded that Baldoni's actions did not constitute sexual harassment. In her filing, she acknowledged that the only issue she believed warranted trial involved the birth video, which clearly wasn't sexual harassment, and Jaime Heath entering her trailer, even though he knocked. Those were, according to Blake, the only two matters at issue. Wayfarer's response highlights this point. Lively seems to recognize that Baldoni's conduct alone doesn't support her claims. Instead, it boils down to a comment about circumcision blacked out in filings, but easily inferred that occurred after she raised the topic and before she agreed to work on the film. Other discussions cited involved conversations about sex and intimacy while planning scenes for the film, and a comment about her weight made to someone uninvolved in production. Wayfarer notes that she now attempts to frame Heath as the poster boy for sexual harassment based on a brief, awkward interaction, despite Lively herself explicitly telling Heath, "I'm not saying you are trying to cop a look." Similarly, Heath showing a video related to his child's birth contextualized in producing a film with a major childbirth scene was uncontroversial to others, including Baldoni and Angie Giannetti. After months of discovery, Lively has not presented any evidence that meaningfully advances her claims, and whatever concerns she raised were resolved once they were brought up. Even Lively does not dispute that the second phase of filming, including all scenes involving her, proceeded without incident. What is especially notable about Wayfarer's strategy is how many avenues exist for the judge to dismiss the case without ever questioning Blake's credibility. The court could avoid making any statement on whether she is lying and still dismiss her claims. For example, the judge could rule that phir does not apply extraterritorially, or find that she failed to establish an adverse employment action. These straightforward legal arguments provide multiple paths for dismissal, independent of any assessment of the sexual harassment allegations themselves. On the summary judgment side, the court has another straightforward way to dispose of the case without ever ruling on the sexual harassment allegations. If the judge determines that Blake was an independent contractor, all of her discrimination claims under federal law effectively disappear, because independent contractors are not considered employees and therefore are not protected under those statutes. While the EEOC allows some independent contractors to be treated as employees, that requires passing a specific test to establish employee status. California law also has an exception for business-to-business transactions, which bars independent contractors from exercising employee rights even when they work closely with a business. In the motion for judgment on the pleadings, Wayfarer argues that phir cannot be applied extraterritorially and that Blake failed to allege an adverse employment action. In the summary judgment, they further argue that she was not an employee at all. Either path provides the judge with a solid legal basis to dismiss the case without needing to make any determinations about sexual harassment. These arguments also allow the court to rule without questioning Blake's credibility. Against this backdrop, Blake's legal team is effectively trapped, trying to defend multiple arguments at once and admitting they cannot do so fully. Regarding the adverse employment action claims, Blake attempts to classify retaliation or publicity efforts as adverse actions, but it is now undisputed that no material aspect of her employment was negatively affected. Her compensation was unchanged, and her role was not diminished. That alone is sufficient to defeat her phir claims. She attempts to expand her alleged employment to include post-filming activities, including her campaign to secure a PGA mark. However, she was never hired as an editor, director, or producer. Her involvement in post-filming work demonstrates an expansion of responsibilities, not a contraction. She ultimately received the opportunities and references she sought, including the defendant's endorsement of her PGA mark, which she proudly described as an achievement rather than a setback. A footnote in her filings sheds light on her producer credit. She acknowledges that she undertook editing without any promise of a producer credit and was not granted a formal producer title until June 2024. This demonstrates that her efforts were motivated by a desire to achieve the PGA credit, which signifies primary producer responsibility and substantial creative control. Possessing this level of control further reinforces that she was an independent contractor, not an employee. In this way, the argument works on two fronts. It undermines her employee status while simultaneously showing that her claims of adverse treatment lack any factual or legal basis. Wayfarer's response also meticulously Lively's claims regarding defamation and false light. She has been unable to identify any statements or publications that were actually defamatory or critical of her beyond what was already publicly known. Much of the criticism she cites, including videos of her prior statements, was already in the public domain before the film's release. Yet she now attempts to claim that the resurfacing of these statements somehow constitutes a false light, or that she was harmed because of her alleged takeover of the movie. Wayfarer points out that there is no evidence of any retaliatory motive. She cannot show that the defendants acted with any intent to retaliate, nor that they hired Melissa Nathan to target her personally. Nathan was retained for defensive purposes, preparing in case Lively ever pursued legal action, not to act against her because of any protected activity. The PR efforts cited were related to disputes surrounding her taking over the production, not any protected activity on her part. The arguments regarding her status as an independent contractor are particularly strong and provide yet another path for dismissal. Wayfarer notes that simply ruling Lively was a contractor could resolve the case entirely. Under California law, the business-to-business exception applies here. The work was performed pursuant to a bona fide business-to-business transaction between It Ends With Us Movie LLC and Lively's loan-out company. Blackie link. Relevant factors outlined in California Labor Code, 2776, which overlap with the Reed test, all confirm this classification. Blake Hill was free from the defendant's control, both contractually and in practice. Services were provided directly to the defendants, not to their clients, and the parties had a written contract specifying payment. Blake Hill had a registered business location separate from the defendants, and Lively's customary role through Blake Hill was to lend her acting services, the same services performed under this agreement. Additionally, applicable New Jersey business taxes were withheld, further confirming the independent contractor status. Taken together, these points strongly support the conclusion that Lively was not an employee, undermining her phir and other employment-based claims, while simultaneously showing that there is no evidence of retaliatory or defamatory conduct. Blake provided the same services to other clients and actively advertised her availability to do so. She even insisted on adjustments to the defendant's production schedule to accommodate Blakehill's ability to provide her services on another film. Blakehill, as the business entity, supplied the relevant instrumentality for Lively's work, negotiated its own rates, and had the authority to demand changes to location and hours of work. Importantly, Blakehill was not part of a specialized industry requiring a contractor's license, further distinguishing her arrangement from that of a typical employee. Wayfarer emphasized this point strongly, stating, "Far from a typical employee, Lively independently contracted through her own private business entity and exercised tremendous control while maintaining the right to work on other projects for other businesses. If she is not an independent contractor, then there is no such thing as an independent contractor." Indeed, Lively's overlapping work on another simple phir in the spring of 2024, while post-production on this film was ongoing, demonstrates that she was simultaneously working on multiple sets through Blakehill. Defendants also highlighted that she abandoned her contract claims against Wayfarer, offering no defense, which led them to request dismissal of those claims. Perhaps most damaging, Wayfarer noted that Lively did not meaningfully defend her damages claims. As they pointed out, Lively fails to oppose defendants' damages arguments. Her damages arguments confuse the issue. She claims standing to pursue damages to her own reputation, but falsely equates personal reputational harm with speculative lost profits purportedly sustained by separate businesses. In short, she neither substantiated the harm she claimed nor demonstrated a connection between her personal reputation and any actual business losses. Lively has no standing to seek such damages, which, in any event, are far too speculative. In contrast, Cantu was awarded non-economic damages because harm to his reputation directly impacted his ability to secure oil and gas contracts, not for speculative lost profits. The other cases Lively cites involve entirely distinct issues, such as standing to sue on a contract or to sue corporations for misrepresentations. In this case, she is attempting to claim damages for companies that were not parties to the lawsuit, as well as for personal reputational harm, because those companies were not involved, and because she did not defend her claims. The damages arguments are effectively unsupportable and should be dismissed overall. Many of her sexual harassment claims are minor and fail to meet the required legal standard. If the judge applies a rigorous review, much of the case could be dismissed based solely on the judgment on the pleadings. Lively faces significant challenges. She brought this case herself, has largely abandoned her claims against Baldoni, and now focuses on Heath, despite evidence suggesting her allegations are exaggerated or false. Her assertion that being called a liar constitutes defamation is particularly unconvincing and underscores the weaknesses in her case.